we've discussed on a number of occasions, the ability to control
imposes fiduciary duties of loyalty and care on whoever or whatever exercises that control. It's a fundamental principle of business law in most states, including New York and New Jersey, that one sees frequently in closely held businesses. There was a significant decision recently in the Chancery Court in Delaware, considered the premier court on issues involving business governance, and it's going to be considered influential by courts all over the country. The Chancery Court in Delaware held that when exercising its controlling voting power to change the status quo, the majority cannot cause harm to the corporation or its minority stockholders through intentional, knowing, or grossly negligent conduct. The key point here is not so much the application of the specific Delaware test, in my mind, as it is an understanding that the ability to control a business often creates a greater obligation than to vote the controlling interests of an individual or group of individuals in a way that negatively affects the interests of the minority owners. State laws can vary, but the principle holds generally true. Majority owners, therefore, should be aware of their own exposure, and minority owners should be vigilant in protecting their rights. The case involved the minority shares of Sears Hometown and Outlet stores. It was in bankruptcy and in the midst of liquidation proceedings. The court held there was no breach of fiduciary duty, but the transaction at issue had failed to meet the standard of fairness that applies when a controlling majority has an interest in the transaction. Lampert got involved with Sears when he was the chairman of Kmart, and he engineered the acquisition of Sears by Kmart in 2004. Lampert used his controlling authority to cash out the minority shareholders of one of the less profitable lines of business at a price that the minority found objectionable. Court said he'd failed to meet the entirely fair standard that applied in such a transaction, and he awarded the shareholders $18 million. Court said a controlling shareholder is not prohibited by law from using its voting power to prevent a board action. The court held that Lampert had satisfied the requirements of enhanced scrutiny that were applicable under the circumstances. Lampert's actions were necessarily and sufficient to neutralize what Lampert had perceived as a threat. However, the court went on to reject Lampert's valuation in the transaction, finding that he had not met the strict scrutiny standard. The court awarded damages of $1.78 per share, or $18.3 million for the class of minority shareholders that brought suit. The opinion is significant because it maps out the contours of the fiduciary duties that a controller owes to minority stockholders when it's exercising its voting powers. And again, those are going to likely vary from state to state. But what the decision does tell us is that if you're a controlling owner of a business, you do need to exercise care when you're taking actions that the minority is going to be affected by and over which it has no control. The rules that are going to apply will depend on the circumstances, and it will depend on the law of the state that's being applied to that particular case. But before acting, the prudent majority owner of a business is going to consult with somebody to consider the applicable law and to make sure that there is a fair process in place and that the result is likewise fair. Thanks again for listening. If you have any questions or want to reach out to me, my contact information is below the video.